So without further ado, it's a very exciting topic. If you haven't looked at manorial court rolls, some of you went down to the YS yesterday and heard about the special significance of the Wakefield ones. It is a growth area. A lot of new work being put into the Manorial Documents Register, which, if it isn't already, will be part of the overall search on discovery on the National Archives website, which will be good in a way because people will find it that didn't before, and those that were used to a concentrated and itemised search will have fun. So without further ado, I'd like to welcome my good friend and very experienced archivist, Sylvia Thomas, to tell us about Wakefield court rolls. Thank you.
Is that yes. Right, thank you very much. Yes, I can tell I'm on now. Right, the Manor of Wakefield. It was the largest manor in the country, covering numerous townships within West Yorkshire, from Normanton in the east to Heptonstall and Stansfield in the west, Holmfirth in the south, and a separate outpost of Eccleshill in the north. I'll get used to this. No? Ecclesfield, in the north of the manor. That's it. Right, the Yorkshire Archaeological Society is lucky to own the records of this manor, which go back to the late 13th century and include an enormous series of parchment and paper rolls, one or more for every year from 1274 until the manor's jurisdiction came to an end in 1925. The rolls record the proceedings in the courts, which were the means by which the manor was governed on behalf of its lord. All tenants who lived within its boundaries, whether free or bondmen, had to attend the court from time to time as a condition of their tenure. In the earliest days, we also get evidence of the lord of the manor's jurisdiction over minor law and order offences. But as time went by, the courts came to focus mainly on the transfer of property from one tenant to another. This had to take the form of a surrender of the land back into the lord's hands, and then a grant by the lord to a new tenant, although the original tenant could choose who the new one would be. Because the court was so much at the heart of everything that happened on the manor, its records are a tremendous source of information about the people of West Yorkshire. I propose in this talk to illustrate the kinds of information which you can gather from the rolls by using specific examples. Of course, there are 670 rolls to go at, so no shortage of evidence. Before we start, though, let's just see what they look like and how we can access them. This is a selection of rolls, as you can see, of various dates. This is the earliest roll, 1274 to 5. You'll see immediately that it's written in very small old-style writing, and at this date and up to 1733, it's written in Latin. However, excuse me, there's no need to despair because many of the earliest rolls have been published in translation, either in the Yorkshire Archaeological Society's record series, which has recently been reprinted by the Cambridge University Press. There's details of all these on the back there if you want to see, or in the YS Wakefield Court Rolls series, of which 16 volumes have now appeared, and again I've brought one of each there. And if anyone's interested in buying one, I'm selling them today at £10 each. Usually they're 15, so see me afterwards. This is the old record series, what it looked like before reprinting. And these are the Court Rolls series volumes. There was a brief period during the Commonwealth from 1650 to 1660 when Oliver Cromwell decreed that such documents had to be in English and legible. You may disagree about the legibility. But with the restoration of the monarchy, they went back into Latin until this was changed by law in 1732. They were written on parchment, which is sheepskin, although there were also drafts on paper, with additional papers bound in, up until 1738. From this time onwards, they were kept only on paper, which was probably cheaper, but it's given us a severe headache because many of the 18th and 19th century rolls were badly stored in the manorial offices in Wakefield and have suffered as a result. This is the 1621-2 parchment roll. You can see how elaborate the hand is at this stage. They didn't write like that all the way through. Sometimes it's quite plain. This is the 1682-3 roll with its draft. The draft is the small fat one because, of course, it has a lot of papers bound in with it. This is a paper roll in good condition, and there's a closer up. It's very unusual, actually, to have a plan in it. There are just one or two in the 19th century because they were so involved with passing property from one person to another, but that isn't very usual to find that. Here's one in bad condition. It would cost many thousands of pounds to separate the pages of this and salvage any writing that's still legible. At present, all we can do is to store them properly and prevent any further deterioration. Because the manor was so big and the administration of it therefore rather cumbersome, its record keeping remained relatively unaltered over the centuries, unlike many smaller manors which went over from rolls to recording their proceedings in books by the 18th century. In the manor of Wakefield, they carried on using rolls right up until 1925, by which time they were massive and had to be split into 2 or 3 a year. Now for some examples so you can see what they contain. I'm going to start at the later period rather than the beginning and work backwards in time, as that's the way it's usually best to approach family history research. The examples are taken mainly from the rolls which have been published, so you can follow them up yourself if you want to. That's the most recent one that's been published, 1812-13, because it was 200 years and they were hoping there was some evidence of the Luddites in it. There wasn't very much, I must admit, but they did find something. This is an entry now from this roll. The year in the manor changed at Michaelmas, so that's the 29th of September. So most of the business in each roll refers to the year after its number, if you see what I mean. So this is 1812-13, starting at the end of September 1812. It relates to 2 cottages near the tithe barn in Ossett and records the admission of John Wilson of Ossett, now under age, the eldest son of Thomas Wilson, late of Ossett cardmaker, deceased, who was the eldest son of John Wilson, late of Ossett clothier, deceased, eldest and only brother of Thomas Wilson, late of Ossett clothier, deceased, and grandnephew and next heir of Thomas Wilson. The cottages are recorded as in the occupation of William Smith and Thomas Dews, or their undertenants. From this entry, you get a picture of a whole family succession in Ossett, with details of how they made their living. It's probable that the deceased Wilsons may appear in an earlier roll of the court, so it could well be possible to find out more about them. This entry is in the published roll. If you want to trace back in the earlier rolls, the next published volume covers those for 1790 to 92. In the roll for 1790, we find a surrender of 2 messuages or houses in Ossett by John Wilson of Ossett clothier, eldest son and heir-at-law of Robert Wilson of the same clothier, deceased, and grandson and heir-at-law of Robert Wilson of the same clothier, deceased, to one John Archer, clothier. In this case, the messuages are occupied by Abraham Ellis and Job Butterfield. A John Wilson is also joint grave of Ossett. The grave was a manorial official appointed annually from the tenants. Whether these Wilsons are connected to the later ones would require more investigation, but we could look at the intervening rolls to see if there's any further information there. So how would we know where to look if they're not published? Luckily, help is at hand. From 1559 onwards, there are indexes of a sort to the rolls. In the early days, these docket books, here's two of them, are simply a chronological extract of the entries relating to transfers of land, and so you would have to plough through them to look for names. That's an early docket, not alphabetical but chronological, and you get the area of the manor written down the side. But from 1799 onwards, someone had the bright idea of arranging the names in alphabetical order, which makes searching much easier. Here we are. Here's an alphabetical docket. The entries in the rolls are numbered, so you can find what you're looking for, provided that the roll is in a fit state to handle, which isn't always the case, as we've already seen. But the information in the dockets could possibly help bridge the gap to get you back to an earlier period where the rolls are okay. At the court, which was held on the 13th of August 1813, a further admission, this time to land and workshops in Alverthorpe, Wakefield, and land and a mill in Soyland, was made to John Foster and Richard Wadsworth, nephews and next heirs of William Sutcliffe of Stubbin, Sowerby, yeoman, deceased. The roll gives a description of how William came by the land, and says that he died upwards of 2 years ago. It also describes the descent of the two nephews, to show their entitlement to inherit. John Foster of Leering's Heptonstall gentleman is the eldest son of Betty, late wife of William Foster, late of Leering's stuff-maker. The Reverend Richard Wadsworth of Hebden Bridge Lane's Heptonstall clerk is the eldest son of Sally, late deceased wife of Edmund Wadsworth of Monsell House, Wadsworth Farmer. Betty and Sally were the only sisters and co-heirs of William Sutcliffe. From the 1791 roll, we learn that William Sutcliffe was lending money on mortgaged land, so he was probably quite a wealthy man. Not everyone who was admitted to land in the manor was a resident. In the 1790 roll, on the 1st of April 1791, James Newsom of the borough of Southwark, Surrey, Fellmonger, who was the surviving brother and heir-at-law of Joseph Newsom of Dewsbury, wool-stapler, deceased, who was himself the eldest son and heir of Joseph Newsom of Dewsbury Drysalter, was admitted to property in Earl's Heaton. We also find out the names of those who were occupiers of the premises. The two Josephs had occupied a house, warehouses, barns and so on in Earl's Heaton, but another house and some land was in the occupation of Joseph the son, plus John Senior, John Crawshaw, Abraham Thong and lately Thomas Firth. A third property was occupied by Joseph Whitworth, George Exley and lately Jonathan Fothergill. I've quoted these at length to give you an idea of the vast number of individuals whose names can appear in the rolls. Of course, the same surnames and Christian names crop up over and over, and it's important to remember that they may not all be the one you're looking for. There's an extraordinary consistency in surnames in particular areas. We've been hearing about that this morning. Over the whole 700 years of the rolls, and I'll say more about that later. Here, though, still from 1790, are some more Wadsworths. This time it's Mary Wadsworth of Luddenden, spinster, surviving sister of Richard and John Wadsworth, and surviving child of Richard Wadsworth of Rishworth, schoolmaster, and Mary his wife, all deceased. Mary Junior is being admitted to property in Worley and Sowerby, which her father had purchased from one Joseph Godley. Her parents had provided that the property should be inherited successively by their two sons, before coming equally to any remaining children. Mary was the only one left. It's usual to find that daughters come last in the line of succession. It's also normal for property to descend to sons successively, but to daughters to be divided equally among them. Of course, if the daughters are married, their husbands would receive the property in the right of their wives. Sometimes the entries in the court rolls refer to separate indentures or agreements made between the parties, and the contents of these are quite often noted, or a copy enclosed in the roll. Members of the Greenwood family of Sowerby, which, as we've heard, is a very common name in the area, are enumerated in indentures quoted in July 1791. They're named as Thomas Greenwood, the elder of Margate, Kent, innkeeper, Daniel Greenwood of Sowerby, weaver, Mary, wife of James Pickup of Broadclough, Forest of Rossendale, Lancashire, cotton manufacturer, and Susanna, wife of John Nichol of Midgley, weaver, all of whom were children of John Greenwood, said to have been alive in 1766. There's also mention of a Mary Crowther, née Greenwood, and a Simeon Greenwood, also alive in 1766, and perhaps John's sister and brother. Then there are John Greenwood of Blackdyke in Hepton Stall, weaver, Mary, wife of John Eastwood of Hepton Stall, weaver, and Susanna Greenwood of Hepton Stall, spinster, all children of William Greenwood of Higgin Chamber in Sowerby, weaver, deceased, eldest son of the first John Greenwood. Then there are Thomas Greenwood the younger of Margate, yeoman, Mary Greenwood of Haddishelf in Sowerby, spinster, and Susanna Greenwood of Brampton in Sowerby, spinster, all children of John Greenwood of Highley Green in Sowerby, weaver, deceased, another son of the first John Greenwood. So from this, we could construct quite a good tree for 3 generations, noting the potential for confusion through the repeated use of the same names and the danger of jumping to the conclusion that Thomas Greenwood Jr. of Margate was the son of Thomas Greenwood Sr. of Margate, when actually he was his nephew. Very often in the 18th and 19th centuries, we find people leaving land in their wills, and this being quoted in the rolls. Sometimes they surrender it during their lifetime to the uses of their will, and after probate it's quoted on the roll in full or in part. In 1790, Betty Ramsden of Ovenden, spinster, surrendered her property in North Aureham under her will, a probate copy of which is annexed to the roll on the 20th of January 1792, to her dear or reputed son, George Ramsden. If he dies under age without lawful issue, it is to go to her brother Joseph, with payments to her brothers John and Robert and her sister Nancy Aykroyd, her cousins John and William Mitchell, Hannah Kirkham and Betty Staveley. You can see how this could help you to link up disparate parts of a family tree. You can also get useful information on the occupations people had. In Stanley, we have a list of 9 of the younger children of William Abson of Stanley Lane End, labourer, deceased, son of Anthony Abson of Wakefield, yeoman, deceased. Among them we find a shoemaker, a roper, and the wives of 4 labourers, a carpenter, a worsted manufacturer, and a mason. We have to go back a century or so to find the next 2 published volumes of rolls, covering the period from 1687 to 89. Here we still find some people surrendering to the uses of their wills, although it becomes much less usual as we go back in time. The surrenders can offer interesting insights into family concerns and the testator's desire to control his offspring. At the court of the 10th of August 1688, it was testified that Jonas Burnett, Sr. of Durker, in the parish of Sandal Magna, had surrendered property there to the uses expressed in his will, whereby he named Joseph Burnett and his lawful heirs to inherit unless he were to marry Mary Brooksbank of Crossland, spinster. If he did, the property would descend directly to Jonas Burnett, grandson of the testator. If Joseph married anybody else, he could have the land. If someone simply died without leaving a will, the heirs would come to court to ask for leave to inherit the property, for which they had to pay a fee to the lord. At Sandal in February 1688, Mary and Margaret Booth, sisters and heirs of Thomas Booth, son and heir of Thomas Booth, late of Chapelthorpe, schoolmaster, paid 7d plus 4d rent to inherit his land in Sandal. At the same court it stated that the sisters, being over 12 years of age, came before the steward and chose John Cook of Wakefield, clothier, as their tutor and guardian until they reached 21 years. He paid 12d and would have custody of the girls and their lands until then, and would have to render an account to them at that time. Another arrangement for children was made by a widow, Susan Midgley of Lighthazels in Sowerby, who on the 1st of April 1688 surrendered her property there to others so that it could be sold to provide for the education and maintenance of Elizabeth, Judith, Mary, Martha and Nathan, children of Susan and her late husband Nathaniel Midgley. There was another controlling testator in 1688. Mary Maud of Halifax, widow, left her property to trustees to support the education of her 2 grandsons for 12 years, after which the grandsons are to have the property, provided that they do not give their mother, Sarah Maud, any maintenance or allow her to live with them at all for her whole life. There is unfortunately no indication of why Sarah was held in such low esteem by Mary Maud, but further research might, I suppose, reveal it. In the same role, we find elaborate provision made by a surrender, although in this instance there's no reference to a will. The surrender in the testator's lifetime sets out all the payments he wished to be made. Gervase Hatfield, senior of Stanley, left his property to his son Oswald Hatfield, gentleman, provided that Oswald pays sums of money as follows: £100 to Thomas Hatfield, another son of Gervase, within 12 months of his father's death, and £30 to Saville Hatfield, another son, if he lived so long and reached the age of 21. Elizabeth Hatfield, daughter, is to be paid £4 a year for life, and Mary and Martha, 2 other daughters, are to have £30 each at the age of 21. A further £10 is to be paid at age 21 to Elizabeth Hanson, daughter of William Hanson of Stanley. In 1664, we see that we can pin down the date of death of a tenant fairly closely. At the court held at Wakefield on the 28th of October, it was testified that Richard Liversidge, senior of Burke House, on the 16th of July last, surrendered properties in Ossett to the use of his sons William and Richard Jr. A few entries after this, we find Dorothy Liversidge, now widow of Richard Sr., seeking licence to have the wardship of John Liversidge, son and heir of Richard, during his minority, and custody of Richard Jr. and William. Clearly her husband had died during the previous 3 months. I mentioned the paper draft rolls which accompany the final fair versions. There are occasional ones of these surviving from the 15th and 16th centuries, then for most years until 1737 when they stop. These can give us additional information about the people on the manor, for example, whether jurors could write or sign their names. You can see at the bottom there, people have put their mark. Sometimes gaps in the main roll can be supplied from the draft, and there are occasional variations between the 2 versions. Extra documents, such as copies of indentures and wills, plus the bylaws and lists of jurors for each court, are filed along with the draft. This is the published version of the previous slide, so you can see what it actually says. You can get some intriguing insights into life on the manor from the bylaws of the various townships. On the 19th of April, 1665, the sworn men of Shelley Township said that John Hay took John Naylor as a squatter in his house, which was against the law. The presentment filed with the draft roll says, "Item, we present John Hay for a cottage for taking of John Naylor and his family into such housing of his as formerly hath been no dwelling house, according to the statute." So I suppose he'd put them up in the barn or something, and they weren't allowed to do that. On the 10th of October 1664, in Halifax, we find witnesses stating the bylaw that John Watson of Halifax, pipe maker, do pull down and remove his pipe furnace, which is a common annoyance to his neighbours, before the last day of June next coming, upon pain to forfeit £5, and to forfeit 20 shillings for every month after the said last day of June, that it shall be unpulled down and removed. That's a good word, isn't it? Unpulled down. John Watson denied it was a nuisance and elected to be tried. The court found it was a nuisance and fined him £10. Most of the land held by tenants on the manor was called copyhold. That means it was held on the evidence of a copy of the entry in the court roll. This type of tenure was the successor to that of the bond or villein tenants of the Middle Ages, and it was distinct from freehold, which would be transferred by charter or title deed. Although it had its origin as a low-status, unfree tenure, From the 16th century onwards, all kinds of people of all classes were copyholders. The handing over of copyhold land to the lord was symbolised in court by the actual handing over of a piece of straw by the surrendering tenant to the steward of the lord or his representative. This straw is sometimes still to be found woven through the note of surrender on the draft roll, and there you can see one still in place. There were two different types of court in the manor. The court held for the tenants, both free and bond, which took place every 3 weeks at Wakefield throughout the year, and the court leet or turn, at which the lord was delegated to exercise jurisdiction in minor criminal cases and infringements of law and order on behalf of the Crown. The turn took place twice a year after Michaelmas and Easter. This is where we find the records of bylaws, as well as, in the early years, prosecution for crimes and misdemeanours. At the turn, we meet the representatives of all the townships within the wider manor, who had to send a constable and 4 sworn men or jurors to report on any matters within their areas. They were elected each year, and their names appear in the rolls. I mentioned the wider manor as the 3 weekly courts dealt only with land held in demesne, that means directly by the lord, although let out to tenants. This comprised broadly the townships surrounding Wakefield, the townships in the Home Valley around Home Firth, and the townships around Hipperholme and Sowerby in the Calder Valley. The rest of the manor had been sub-infeudated or passed down in early times to subsidiary lords of sub-manors. So the bit... Oops, sorry. That's what I wanted. Yeah, the bits that were held directly by the lord were the bit round Wakefield, the Graveship of Home, and the bits round Sowerby and that part, Halifax. But other areas of the manor were also part of the wider manor. This is a court roll for the Manor of Shelley, one of the sub-manors. They held their own courts for tenants, and the tenants were only obliged to attend the Wakefield Manor courts for the turns. The turns were held at 4 centres: Wakefield, Brighouse, Kirkburton and Halifax. Although for the convenience of tenants, you often find business to do with tenancies being done at the turn, presumably to save people a long journey to Wakefield. At the turn in October 1651, we hear of a different kind of convenience. The Halifax jurors say, "We present Michael Bentley for making a jakes," that's a privy, in his garden, over the water running to Halifax, and his walls being so high we cannot get over to view it. He was fined 20 shillings. Halifax actually seems to have been rather a rough and lawless place. Is it different now? I don't know. Anthony Gill was fined 40 shillings for keeping a dog pit and a bowling alley, and Richard Leroyd, the younger, did fight a cock there for 5 shillings, he being an apprentice to Henry Croft, fined 6 and 8 pence. Robert Lang of Halifax is a common gamester at unlawful games as bowling, dice, cards and cockings, and that he is a common swearer, fined 6 and 8 pence. There are numerous references to people in Halifax making an affray, with or without drawing of blood. The penalty was much greater if you drew blood. It happened all over the manor, but was particularly frequent in Halifax. Whether Saturday night was particularly bad, I don't know. Elsewhere in 1651, there's a note on the draft roll which says, "Mr. Leake, we do desire you would grant by copy or otherwise 1 cottage house divided into 2 dwelling houses in the occupation and possession of John Naylor and Barnabas Fossard, with 2 little garden steads thereunto belonging, which houses they builded at their own charge, and taken out of the Lord's waste in this Graveship of Sandal, to the use of John Naylor and Elizabeth his wife during their lives, and the longer liver of them, and after their decease to Jane Ashforth, daughter and heir apparent of the said Elizabeth, and the heirs of the said Jane forever, the other remaining half part of the house in the possession of Barnabas Fossard and Alice his wife during their lives, and after their decease to Mary, daughter and heir apparent of her, the said Alice, and her heirs, and these we desire, because we would it should respectively go from the parents to the children as aforesaid. This house and garden stead contain about 20 yards in length and 16 yards in breadth. So you find out all about their nice little house. These parents were providing for their daughters, and we often find this, although, as I said, they tend usually to find themselves at the back of the queue when there are sons. In October 1639, William Walker of Midgley, yeoman, surrendered the reversion of his property after his death to the use of John Walker, alias Stead, reputed son of William and his lawful heirs, with only a remainder to Mary Walker, presumably legitimate daughter of William and her heirs. At this period, even when they are being prosecuted, women are frequently referred to simply as wife Thomas Smith, for example. In one case in North Aram, the bylaw says that we pain Uxor Hugh Romsden, Uxor of course means wife in Latin, we pain Uxor Hugh Romsden, Edward Northing of the Knightroyd and his mother, George Whitley, Marmaduke Ball, to make a sufficient horseway every one against their own ground before midsummer next, in pain of every one of them 10 shillings. So they could be fined, but they didn't actually get their names put in the roll. The Dean family of Ovenden is another where it's possible to trace several generations from entries in 1639 after the death of John Dean, son of another John Dean. The father had obviously pinned his hopes on his son to inherit and pass on the land and the ancient old house at Black Hill in North Aram to his male heirs, and failing that to his own male heirs if any were subsequently born to his wife Grace. But apart from his only son, John the Elder had 5 daughters, and so they were all entitled to inherit a 5th share. In describing all this, we're told that John Dean, senior of Ovenden, was the second son of Robert Dean of Jackroyd, Ovenden. He was married to Grace, and their children were John, now deceased, Isabella, married to Dennis Illingworth, Grace, Judith, married to Richard Ramsden, Prudence, and Sarah. Just to confuse matters, in the same roll, a few entries further on, we get 2 daughters, Anne and Grace, of a Grace Dean, deceased, widow of a John Dean of Ovenden. These are not the same as the first lot of Deans. Their mother, Grace, was the daughter of John Sutcliffe of Amblerthorne, who had a sister, Mary, married to Nicholas Smith. Anne and Grace had had 2 brothers, Richard and William, both deceased, and William's son John had also died. They all seem to have died in 1639. Perhaps it was some sort of epidemic. The roll enables us to reconstruct 4 generations of the family. It could be that these 2 lots of Deans are related, but not necessarily. Dean is a very common name in the graveship of Sowerby and is found over hundreds of years. When I've been looking through the rolls to carry out searches for specific surnames, I've noted that certain names are regularly associated with particular graveships or divisions of the manor, and one can often guess which area the entry relates to just from this. For example, in Sowerby graveship you'll find Dean, Greenwood, of course, Fairbank, Patchett. In Home you'll come across a preponderance of Littlewoods, Tinkers, Kays, Morehouses and Seniors. In the area around Wakefield you'll get Savills, Nevilles, Hatfields, Claytons and so on. Though one name that's often found in Wakefield, in the earliest rolls, dies out later, and that is Sprigonell. The last mention in a published roll dates from 1665, when John Sprigonell, a free tenant, is twice fined for failure to appear at court. It would be interesting to find out why they disappeared. Although married women wouldn't be tenants except jointly with their husbands, if the property has come from their family inheritance, they're always mentioned in the entries relating to it. If a surrender takes place in these circumstances, the wife was always taken aside by the steward to confirm, without the presence of her husband, that she consented to the transaction. This was to prevent a woman from later claiming that she'd been coerced into surrendering her land because she couldn't go against her husband's wishes. I think this must have been done more for the sake of avoiding future court cases than to safeguard the wife's rights, since the court could scarcely ensure that she wouldn't be subject to intimidation or punishment by her husband subsequently if she failed to consent. From the family historian's point of view, though, it's very useful as we get names and connections that we might otherwise struggle to find. A more unusual entry from 1583 relates to John Townend, a free tenant in Dewsbury, who held 8 acres of land and meadow in Sockage, which is freehold, by courtesy of England after the death of his wife Agnes. This is the right of the husband to hold her land for his life after his wife's death. Agnes had been heir to her relative William Firth, deceased. Now, Robert Haig of Sowood, John and Agnes's son-in-law, is to do fealty to the Queen and pay a year's rent, 3 and 4pence, to be admitted to the property in the right of his wife Elizabeth. The roll tells us that at the time of her father's death, Elizabeth was of full age, being 45 years and more. If a woman was left a widow in property which had belonged to her husband alone, she would have rights after his death, but not to the whole. Dower represented a third part for life of the property, and sometimes heirs would fall out with the widow over it. Alice Robert, in the Graveship of Home in 1537, had to sue John Robert for a third share of 16 acres of land belonging to her late husband Oliver Robert. There's also an unresolved case in which John Wormwall sued Cecily Maud, widow, over land in Ossett, which she claimed as dower from her late husband, John Clayton. But cases could take many months, if not years, to resolve. And this one, despite being mentioned at several successive courts, never comes to a conclusion, possibly because one or more of the parties died. January, August and September 1550 and February 1551 and June till autumn that year saw a high incidence of epidemic diseases such as bubonic plague, sweating sickness and perhaps influenza or typhus. Halifax Parish Register shows evidence of sweating sickness with 49 burials in August 1551. People would grant their land to their children in the prospect of an intended marriage. In Sandal in 1551, John Hardgate surrendered land for a term of 21 years to Ralph Addy and Joan Hardgate, John's daughter, whom Ralph intended to marry. They were to pay John rent of 27 and 10pence for the term of the lease. In 1537 in Sowerby, William Greenwood surrendered a close called Jackland Mitchell, or Mickle, to the use of his son Richard, and the heirs lawfully procreated between Richard and his intended wife, Margaret Midgley. They are also to pay a rent of 26 and 8pence per year to William for the term of his life. The court rolls can occasionally provide evidence of provision being made for illegitimate children. We've seen a couple of examples already. In 1585, John Green of Lane in the Graveship of Home surrendered a reversion of property after his own death to his bastard son John for life, and after that to James Green, son and heir apparent of John Green Sr. This doesn't necessarily mean that James is being badly treated. It may be that his father had other property for him to inherit. In this case, the name Green is given to both father and illegitimate son. In other cases, the name may not be the same, so the roll may give some clue to family links. Is there a link to be found in the surrender by John Rishworth and Elizabeth, his wife, of land in Thong, and a house and a part of a barn which Elizabeth herself had recently received, to Thomas West of Little Breton, bastard, alias Thomas Herring? Oh, talking of weddings. Fantastic. Oh, well. Anyway, back to the bastards, yes. If the names are different, it could just give you a very good, useful lead. The Manor of Wakefield seems to have continued to function in a relatively unchanging fashion, with few, if any, explicit references to momentous national events. The roll for 1536, one of the few not in the YAS archives, but actually in the Brotherton Library at the University of Leeds, shows very much reduced business at the Great Court in October and considerable disruption to the normal run of courts. almost certainly due to the effects of the uprising known as the Pilgrimage of Grace, in which local people were known to be involved. This increase in tension may have led to an increase in suits in the Manor Court for debt and trespass, and possibly in affrays and violations of manorial customs. Isabel Jepson, widow, was sued for trespass by John Field of Wakefield. She's known from the records of the Court of Star Chamber to have brought a suit there against Thomas Tempest, son of the steward of the manor, Sir Richard Tempest, for procuring the murder of her husband. Nothing like that, though, appears in the court rolls. It's all very, you have to draw conclusions from sort of looking at it sideways. As we go back to this earlier period, we begin to find some different kinds of court business in addition to the passing on of land. In the draft roll of October 1537, we find the amercement or fining of various people in Wakefield for misdemeanours, including Parsival, the cardboard maker, dwelling in Kergate, for breaking one penfold. We also find evidence of the trades which people had. Tenants had to take their bread to the common bakehouse to be baked, rather than doing it at home. If they didn't, they were fined. But the baker also had to perform his duty and bake, or he would be fined. Memorandum that I, Lewis Richardson, the King's Baxter, complaineth of these persons following to the great inquest of the town of Wakefield. First of all, of Agnes Milnes, item of William Wall's wife, item Thomas Thurlston wife, item Henry Godman wife, item Geoffrey Richardson wife, item John Shuttleworth wife, item Thomas Penson wife, with other that withdraws their course to the bakehouse contrary to the custom and manner of the town. There all fined twopence each, but the jury also pained the Baxter that he do his duty in baking all such bread as comes to the bakehouse according to the custom thereof, upon pain of every bushel fourpence. So I guess they'd been having difficulty and decided that they'd just do it themselves, and he didn't like it. In the same month, we learn about conditions in the centre of Halifax once again, where William Stokes, Thomas Stokes and George Dodgson are fined for receiving strange beggars and vagabonds into their houses by night. The streets are not properly kept up, including the marketplace, where people make dunghills, and the butchers let their boards stand all week long, both night and day. Also, John Parkinson and William Midgley, otherwise Milner, are immersed for making a fray and breaking the king's peace. In Sowerby, Edward Crossley doth trouble the watercourse, while John Patchett keeps a sheep warrior. When you go back a further century to 1433 to 6, you find far fewer land transfers than in the 16th and later centuries. At this date, surnames are not quite as fixed as they are later on, although you still find familiar ones. Sometimes they may reflect a person's real occupation, or they may have become true surnames passed down the generations. Many, of course, George may tell me that I'm getting all this wrong, so if I'm wrong, ask him. Many names which persist for centuries are derived from place names within the manor, such as Bentley, Gawk-Roger, Illingworth, Oldfield, Priestley, and many others. Also, at this date, you can find people called, in Latin, for example, John, son of Richard. Does this mean his surname was Richardson, or would his son be, for example, William, son of John? We still find family disputes and evidence of the trials of daily life. On the 13th of November 1434, Matilda Simpson sued for land in Hipperholme. Richard, son of her late husband John, I'm not sure whether he was her son as well, had denied her right to the land because she had adulterously left her husband. She counterclaimed that they'd been reconciled. The grave of Hipperholme was ordered to summon a jury of 12 tenants to decide the matter at the next court, at which they said that Matilda and John had been reconciled, and Richard the son was fined threepence for a false claim. A lot of misdemeanours for which fines were imposed are in connection with baking bread or brewing ale in unapproved ways. Some are more unusual. Margaret, wife of John Cartmel, in summertime by night mowed and carried away herbage of divers tenants in Alverthorpe. So she must have gone out with a candle in her hat or something. In Stanley, Joan, wife of John Strang, and Ellen, wife of Edwin Gunn, were common scolds in the Ville. In Kirkburton, John Coates chaplain and John Coates Fletcher assaulted the vicar, William Sutton, in the chamber of Matthew Marsh. Also at Kirkburton, William Side of Kexborough sold tainted meat to divers persons. In Emley, William, son of Thomas Goldhaw, and John, son of William Pelter, were common night walkers and eavesdroppers. That's literally listeners under the walls. We do still find family settlements happening, such as that at Scammonden, where William Denton surrendered 40 acres to the use of William his son and his lawful bodily heirs, failing them to Robert, brother of William Jr., and his lawful bodily heirs, and failing them to Thomas, another brother, and his, failing which to Alice, Mary, and Isabel, their sisters, and their lawful heirs. After this, William surrendered the land back to his father for life. In April 1435, Hugh Hazelden came into court and gave fourpence for leave to inherit land lately taken from the Lord's waste before his tenement in Northgate, Wakefield, and other land after the death of his father Thomas. This is of interest as there was a house in Northgate known as Hazelden Hall, of which this is a picture as it was in about 1800, taken from J.W. Walker's Wakefield, Its History and People. The house was only demolished in the late 1960s and is, I think, now the site of Charlie Brown's, so if you get your tyres done there, that's where it is. Hugh Hazelden's daughter married into the Peck family, who owned the hall until 1574, when it was sold to George Savile. I said that the manor sailed majestically through strife and disaster, hardly showing any outward signs of the difficulties people were experiencing. However, when we look back another century to the period of the Black Death, we do get a glimpse of the troubles, albeit indirectly. At the Brighouse Tourne, on the 7th of January 1350, the reports by the townships conclude, the Ville of Stainland presents that Agnes Tingle brewed once at a halfpenny, North Aureham presents nothing, the Ville of Fixby presents nothing, and the Ville of Shelf is dead. There's also an extremely elaborate arrangement made by William Filch, cleric, for lands in Wakefield, Thorns and Sandal. They're granted to Matilda Hogg, probably in return for a sum of money. But after her death, they're to go to Henry, son of William Filch, and his direct heirs. If there are none, they're to go to William's son John, failing him to Matilda, William's daughter, and failing her and her heirs to Margaret, William's daughter, and failing her and her heirs to Adam Filch, William's brother, and failing him to William Adam's son, and failing him to Henry, son of Thomas Mollock, and failing him to Thomas Mollock, brother of William Filch. Life was clearly regarded as extremely perilous and unpredictable. Although we've seen that familiar surnames crop up from a very early date, you do find some rather odd ones. We heard about some this morning, here's some more. They're not usually around nowadays. There's Alice, Little Dick daughter, Nicholas Costnaught, Alice Mab daughter, Isolde M daughter, Hugh Law Dog, and Richard Sour Milk. Finally, what about punishments? Usually there were fines, occasionally jail at Wakefield or York. But because it had infang thief jurisdiction, that means the right to try thieves caught red-handed within the manor, it could execute them either by hanging at Agbrig or at Halifax by the gibbet, which was a primitive form of guillotine. Hence the expression, as I'm sure you all know, from Hell, Hull and Halifax, good Lord deliver us. The last time the gibbet was used was in 1650. A slightly unconventional crime was reported in 1307. Alice, wife of John Kidd of Wakefield, was abducted at night by the servant of Nicholas, the parish chaplain of Wakefield, on the chaplain's horse and on his command, and with the woman's consent. She was taken to Aylesbury with goods belonging to her husband. Afterwards she returned to her husband. No punishment is specified. Nor is it in June 1275 in Stanley. They say that Agnes, wife of Robert de Loftus, entered into the great wood and there killed a lamb and carried it to the house of Philip Moy. She was insane at the time and is so still, therefore nothing is done. Sometimes the custodians themselves can't be trusted. 6th of January 1317, order to arrest Gilbert of the Dean, Richard de Northrin, and John, son of Elias Abraham of Shepley, for stealing a green trocket. I don't know what a trocket is, and it's not in the dictionary, but if anybody does, I'd be interested. Anyway, it was stolen, a green one, a hood and a sheet taken from John Legundo when they were taking him to Wakefield prison. And the said John Legundo is charged with the theft of a woolen cloth worth 10 shillings from Ralph, son of Peter of Dodworth, a woolen cloth worth 8 shillings from William of Langside, another worth 13 and 4pence from Roger of Gunnerthwaite, a fourth worth 14 shillings from John, son of King, and 2 sheets worth 3 shillings from William of the Mire. If you had no goods, you were at a considerable disadvantage. John Legundo, taken upon appeal of Cicely Hoyland-Swain for burgling her house and stealing goods worth 10 shillings, he pleaded not guilty. Jurors find him guilty, therefore let him be hanged. He has no goods. Thomas Morfeaser, that's a jolly good name for a malfeasor, for someone who does evil. Thomas Morfeaser, taken on suspicion of larceny because he wandered about at night, charged with stealing a mare but denied it. The jurors found him guilty. He has no goods, is hanged. When the Manor Court came to an end, the Law of Property Act 1922 brought manorial jurisdiction to an end from 1925, and from then on all copyhold lands were converted to freeholds. This process took quite a few years to complete, and there are 34 volumes of what are called admittance books, all indexed by personal name, which contain transcripts of the assurances required by the Act to be produced before the manorial steward within 6 months of any change of ownership or other matter which affected title to former manorial land, if that land had not previously been the subject of a compensation agreement, whereby the lord was compensated for his loss of rights, rents, fines, and so on. These records continue right up till 1944, and there are numerous other records, including registers of compensation agreements, which go on as late as the 1940s. The collection, the manorial collection, also includes maps and enclosure records and other material, and as a whole it's one of the most important in the country, for which in 2011 it was placed on the UNESCO Memory of the World Register. I hope that this talk has given you a flavour of the kind of information that you can get from the court rolls, and perhaps given you some ideas for further research of your own. If anyone would be interested in transcribing a roll or rolls for publication in the Wakefield Court Rolls series, I'd be very happy to put you in touch with the general editor. Thank you very much.
Thank you, but I probably didn't need it. That was really interesting, and I'm a little jealous because I'm just getting translated about 10 rolls for my parish and found out that you had 670. So, but my question is, the rolls that I'm getting translated now are from the late 1300s and the early 1400s, and now I've got a few in English. And I'd say I'm reading them, and they've got the names and everything, but there's a lot that I still feel that I'm not understanding from them. So things like a freeholder where it refers to a statute and says, well, he only owes this much fealty or this much to the new lady of the manor, but because this one came in after the statute, they owe something different. And I just wondered if there's any books you might recommend that help you to actually, given once you've got it to English, I'm not looking for the medical glossaries, to understand and help to interpret what those rolls are telling you.
There are, yes. I'm desperately trying to think now of the standard work. Chris, you can help me on that. Yes, that's the one. Yeah. Yes. Ah, right.
Hi. You say you got the manorial rolls going back maybe 700 years, written in Latin. At that time, whoever could write Latin, it must have been quite clever or somebody of esteem.
Yes.
Any idea who these people were? Were they clergymen or?
I think they were often, they could have been lawyers, sometimes they might have been clergy as well, but I think lawyers, I mean, I think they'd certainly have been educated people, and they were probably legally trained, quite often at any rate, but sometimes lawyers, sometimes clergy, I mean. But they would have known Latin. But there were, court rolls tend to follow patterns of vocabulary and style and so on. They kind of fully formed into existence in the late 13th century. So there were books originally that sort of advised people how to go about writing such things. But there aren't any sort of primitive ones really. They kind of start and carry on in similar vein. So I think early sort of trial efforts probably don't exist. The very earliest known court roll is 1246, I think, but the earliest one that we have in the Yorkshire Archaeological Society is 1274.
Anybody else? Well, can I just thank Sylvia again for giving us such an insight into a wonderful collection of manorial court rolls. Quite exceptional. This particular one, but I hope it's also inspired you to find out for your own patches and give you an idea of the worth of these. Check out the Manorial Court Manorial Documents Register on the National Archives website. That if you're not quite at the level Kim's indicating, then there's also the super site worked up by Lancaster University in connection with Cumbria Record Office, which has got lots of those glossaries and commentaries, so you know what the documents are, and just get a feel of it, and that's formulaic. So can we thank Sylvia again very much?